Good afternoon and welcome to the Public Service Commission of South Carolina. It is Thursday, January 12th at 3:01 p.m. and we are here today in docket number 2022-188-EC for oral arguments concerning petitions for rehearing and reconsideration and clarification in this docket of the Commission's order. Let's take appearances from the parties. I'm going to note, I'm going to call on kind of in reverse order. Originally, the petitioner was the applicant and respondent, but now we've got those making the motion. So who's appearing for York Electric Cooperative, Inc., Electric Cooperatives of South Carolina?
Madam Chair, members of the Commission, my name is Frank Ellerby, appearing for York and ECSC. Along with me is Chris McDonald of the Tinkin Law Firm and Chris Kuhn, General Counsel of ECSC. Thank you.
Thank you, Mr. Ellerby, and welcome. South Carolina Telephone Coalition.
Madam Chair, thank you. My name is Brad Wright, appearing on behalf of the South Carolina Telephone Coalition. I'm accompanied by my co-counsel Peg Fox, who's also appearing on behalf.
Thank you, Mr. Wright, and welcome. The respondent to the petitions today is Spectrum Southeast LLC, also known as Charter, and who's appearing for Spectrum?
My instinct say, Madam Chair, members of the Commission, is to stand, although I know we don't have to. My name is Mitchell Willoughby. With me is Andrew D'Antoni. Also appearing with us is Paul Warner and Hannah Wigger from the law firm of Shepherd Mullen.
Thank you, Mr. Willoughby, and welcome. We had some interveners. I understand AT&T South Carolina was not appearing today due to another conflict. South Carolina Cable Television Association.
Yes, the South Carolina Cable Television Association appears today through counsel Mitchell Willoughby and Andrew D'Antoni. Also in attendance today is the South Carolina Cable Telephone Association, Television Association's Executive Director, Ben Brazil.
Thank you. And Office of Regulatory Staff.
Good afternoon, Madam Chair and Commissioners. Chad Torrey on behalf of ORS.
Thank you, sir, and welcome. Petitioners, we will recognize y'all first. York, do you want to go first, or okay? Before you begin, I failed to do a commissioner roll call, Mr. Elby. If you would indulge me a second. Let's take commissioner roll call. Appearing virtually, we have Commissioner Irvin. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. Apologize for the interruption, Mr. Elby.
No apology necessary. The charter argument PowerPoint is present up here. I don't know whether y'all want me to review that or.
I would prefer that you not.
Well, I didn't put it there, and I don't know how to get rid of it, but we could scroll down, and I could tell you all the ways it's wrong. How about that? Madam Chair, members of the Commission, as I mentioned a minute ago, Frank Ellerby appearing on behalf of York and Electric Cooperatives of South Carolina. And I will briefly outline for y'all our concerns about the order, the majority opinion in the order that the Commission issued, and our request for clarification. The starting point is 7 commissioners voted. All 7 of you agreed that the Broadband Accessibility Act did not adopt the National Electric Safety Code as the maximum standard, the maximum clearances that an electric cooperative could require for a communication service provider to attach to the poles. However, in the majority opinion, in our view, the majority opinion erodes that holding by the way that the majority opinion just addressed the issues before y'all. And we think that erosion was unnecessary and is inconsistent and contradictory with the plain, straightforward ruling that the entire commission made that the Broadband Accessibility Act did not incorporate the National Electric Safety Code. The portion of the order that bothers us are those portions where the order provides that an electric cooperative has no right to deny an attachment that complies with the National Electric Safety Code. There are other places in the order where, and when I say the order, I'm referring to the majority opinion. There are other places in the majority opinion where the order acknowledges that an electric cooperative can require clearances that are different from the National Electric Safety Code if the electric cooperative has reasons for doing that and the reasons are satisfactory and sufficient under the Broadband Accessibility Act. We think that is the correct ruling, and that is a different ruling than the ruling that Charter sought in this petition and that AT&T sought when it supported the Charter petition. Another aspect of that portion of the ruling that gives us concern is that the majority opinion adopted the statutory construction argument that Charter argued to y'all and AT&T argued to y'all in support of the ruling they asked you to make, which was the National Electric Safety Code are the maximum standards. They presented y'all a statutory argument that said that if their attachments are not prohibited by the National Electric Safety Code, an electric cooperative must allow those. And their statutory analysis that they advanced appears in your order as supporting your finding that York did not meet its obligations under the Broadband Accessibility Act. That is of great concern to us. We think that that presents an opportunity for mischief, for mischaracterization of the order in the future. We think you should clarify in an order on reconsideration that the National Electric Safety Code is not been incorporated in the clearances in the NESC were not incorporated by the Broadband Accessibility Act, that an electric cooperative does have the ability to require clearances that are greater than or vary from the Broadband Accessibility Act, as long as the electric cooperative has sufficient reasons to justify those changes, those additional clearances. And we think that the majority opinion focusing on safety, reliability, engineering concerns, capacity, those terms are found in other portions of the Broadband Accessibility Act. We think it is a reasonable interpretation of the Broadband Accessibility Act that when we're evaluating terms under a pole attachment agreement, under the just and reasonable standard in Section 3030A, to look at those considerations that an electric cooperative should explain with respect to safety, reliability, generally applicable engineering principles, and capacity on the pole. Those are reasonable things. We attempted, in fact, when we prepared the case and submitted the case, that was our view of the case, was that we needed to explain why the York clearances were different from the National Electric Safety Code. We do not think that York or any other electric cooperative can ignore the National Electric Safety Code. We think that electric cooperative needs to use the National Electric Safety Code as the starting point, and then if that cooperative has reasons that fall into those categories that require additional clearances, the Broadband Accessibility Act allows the cooperative to impose those clearances under that just and reasonable standard. We think portions of the majority opinion are consistent with that view. We ask that you clarify that that is the correct and proper interpretation of the Broadband Accessibility Act. Second point, we ask that you withdraw the finding in the majority opinion that York violated the provisions of 58.9 3030B2. That those provisions, the order makes a finding that York denied access to charter to York polls. That issue, the case was not brought under 3030B2. Charter did not file a petition asking y'all to find that York had violated the requirements that it provide access to its polls. So there was no notice that a finding would be made under that provision. That issue was not tried to y'all. We didn't address those issues. We didn't tell you how many attachments Charter has on York polls, how many additional attachments Charter has been allowed to make during the last 2 or 3 years when this case has been in negotiations and while the case was pending. Those are things that could have been part of the record, made part of the record, and we may have had to argue about them, but our point is, or part of the point is, that issue is not properly before you, and we don't think that that finding should be made with respect to an issue that was not pled and was not properly before you. In addition, all of the evidence that was presented in the case was that Charter had been allowed to attach. The issue in the case was that Charter wants a new agreement that makes it easier to attach on different terms and conditions and asks for different clearances to be required. Asked this commission to tell York that the clearances that York was proposing in the contract negotiations were not just and reasonable. And that was the question before the commission. The question wasn't whether access had been denied under 3030B. Just to round out that argument, we presented the contract between York and Charter's predecessor is an exhibit in this case. That contract had been in place since 2004, almost 20 years. Lots and lots of attachments had been made under that contract. Additional attachments have been made. Denial of the right to attach, refusal to allow attachment is just not an issue in this case. The issue properly before the commission is what are the terms and conditions now that the Broadband Accessibility Act has been adopted? What terms and conditions is it just and reasonable for York to require to allow for the attachments to take place? Got ahead of my argument. We believe that, and what we asked the commission to do, and I probably made this fairly clear, we believe that, first of all, to those of you in the minority on this, in the 4-3 minority, we believe that the minority opinion got it right. We believe that York did have reasonable basis for the clearance requirements that we asked Charter to agree to and that Charter rejected. We believe those are just and reasonable under the Broadband Accessibility Act. And we appreciate those of you who agreed with us on that. However, we can live with, York and the other cooperatives can live with the determination that the majority made, which is we're not convinced that those clearance requirements that York required are just and reasonable. We understand that. We heard you loud and clear. We read the order. What we ask for you to do is to clarify that the once and for all that the NESC a communication service provider does not have a unfettered right to attach to poles as long as the proposed attachments meet the clearance requirements of the Broadband Accessibility Act. That instead the rule should be the electric cooperative must offer access on just and reasonable terms. The electric cooperative must explain any variation from the National Electric Safety Code by focusing on safety, reliability, capacity on the poles, and generally applicable engineering considerations. We think that's a reasonable outcome. We believe that the other thing that the commission needs to do is this is just one element of the contract, the clearances. We do not have a full-blown contract. We asked the commission to clarify that the matter should be sent back to the parties. York and Charter should resume negotiations and should negotiate with towards obtaining a pole attachment agreement that is consistent with the commission's decision. And we got loud and clear. We have received the message that the commission did not approve of the clearance requirements that York was proposing in this case. We have taken your thoughts and questions during the hearing. We've taken those seriously. We have looked into finding contractual approaches to address York's concerns that they talked to y'all about at great length, which relate to the fact that they've had a hard time, not only with Charter, but with other communication service providers in being paid costs related to moving facilities and putting up additional poles and reimbursing York when York had to move facilities on poles. The existing contracts require those funds to be paid by the communication service provider. The example that we most often used was a 40-inch attachment on a pole that does not have a transformer on it, and then a co-op member moves into the lot that would be served by that pole, and a transformer must be put in place to allow that co-op member to receive service, and so the transformer has to be moved. Under the existing contracts and proposed contracts, the obligation to pay to move that transformer is on the communication service provider whose attachment needs to be moved. Mr. Basha told y'all it was hard. He struggled to get communication service providers to respond and to move their facilities. And when York, in order to get service to its member, went out and moved the facilities itself and sent the bill to the communication service provider, those bills were ignored. And that was frustration that led to York implementing the procedures that they implemented. What we have looked into, and we plan to, as we go back to negotiate with Charter on a new contract, there are companies that sell bonds that cover pole attachments. They're pole attachment bonds. That's a contractual remedy. Some of y'all pushed us to think more creatively, and we appreciate that. So, and these are specifically pole attachment bonds. I don't think that they are in widespread use in South Carolina. However, they are available in other parts of the country. They're something that we intend to explore. We've been in touch with the companies that sell them. They are in widespread use in other places, and that's the kind of thing that we would like an opportunity to put in place so that York can be protected, attachments can be made at NESC levels, but York can be protected if the attachments need to be moved, and we think and hope we'll get a higher level of responsiveness from the communication service provider if we can put some provisions in the new pole attachment agreement that put some teeth in those obligations, so that there is something to require the payment to be made, and we look forward to the opportunity to do that. We think there is, and given the responses by both Charter and AT&T, it appears that there's agreement that the NESC, that an electric cooperative can justify additional clearances beyond the NESC. Not that we expect to be trying to do that for York. Don't know what we'll do about that. Not saying we expect to go back to the drawing board and ask for 83 inches and 17 and a half feet. I'm not suggesting that. We believe that York can negotiate an agreement. We think we can explore. We want a chance to explore putting a bond in place to make sure York is protected. And we ask that you reconsider your order, revise it as outlined in our petition and in this argument, and send the matter back to the parties to complete the negotiation on the contract. So I'm happy to answer any questions that you have, and otherwise I'll sit down.
Commissioners, questions for Mr. Ellaby?
Madam Chair.
Vice Chair Powers?
Mr. Ellaby, what's keeping you from negotiating now?
I think, but we probably could. The litigation shut down the negotiations. I would tell you that if we can get clarity on the issues that I described, I think we could resume negotiations promptly, and I hope that we would be able to get to a new pole attachment agreement in fairly short order.
Well, my only appeals that I've had as a legal career were criminal and a lot of family court stuff. And it was always pointed out that the judge had the authority to interpret or accept a lot of discretion. Does this panel not have that same discretion? Because I noticed a lot of it said in your brief that we misinterpreted rather than an error of law. Do we not have discretion sitting here as commissioners?
Commission does have some discretion, yes, sir. We think that, and I don't want to argue an appeal at this point, but we think that a court would give some deference to an agency's or the commission's view of statutory provisions, but certainly if there are legal errors, those are reviewed by the court de novo, and we think there are some with respect to some of the issues. I don't know if I've ever argued or done an oral argument on a petition for reconsideration before, but and so I haven't actually had to address that to somebody that voted against me.
Well, I think one thing that came out in the brief too was that and you talked about not the issue not being before us that came up in the testimony. There was, this has been going on for some time. You're saying that York had no notice of this issue was going to come up about pole attachments. You mentioned it looks like page 9 in a footnote that if you had known, you would have presented certain testimony, or York would have presented certain testimony. I don't see how you can quite say you didn't know, or do you really, let's say if this was an appeal, you want to say to a court that York wasn't prepared, or if something comes before us, we have a right to consider it if it comes up in testimony, do we not?
problem is the case was brought under subsection 58.9 asking the commission to set or to make a determinations as to just and reasonable terms under a new contract. I mean, there was an existing contract between York and Charter. There was no allegation in the pleadings that said York has violated its obligations to allow attachments. There's a contract in place, attachments had been allowed, and the 3030 B2 says specifically that the communication service provider has to pay the cost of of providing access to the poles if there's not capacity on the poles. So the question before the commission was, what are just and reasonable terms for the new contract? There wasn't an allegation that the existing contract denied access to Charter, and that wasn't addressed in the testimony that we would have put a different testimony up. So.
Well, I think my point is that when it came up in testimony, could you not have objected or provided that information? I just remember questioning the head of York, and I remember there were several things I asked him he just didn't know the answer to, and I just wondered why.
Well, I never we didn't hear any questions that basically said you're denying access. The argument was if these clearances that you're requiring don't allow enough room on the pole and therefore increase our costs. And we litigated that issue. I'm suggesting to you that that's a different issue from denial of access. And we met the issue about what are just and reasonable terms. We persuaded only 3 of the 7 of you that our terms are just and reasonable. We now will go back to the negotiating table, and we will negotiate an agreement that is consistent with the majority opinion, as I hope is modified following as you consider the petition on reconsideration.
Okay. Thank you very much.
Thank you, sir.
Commissioner Justin Williams.
Thank you, Madam Chair. Attorney Ellaby, I appreciate everything that you shared. It seems there's a lot has been going on since we've made our decision, so appreciate all that work. I don't want to prolong the issue, but I just want to make sure that I understand, since a part of this petition is for clarification. When I read Spectrum's petition, just with a simple word search, the word deny comes up 11 times. And just so I'm clear, what do you think they were talking about when they referenced denial?
Well, what we understood that they contended that our clearances were not just and reasonable. First of all, they argued that the NESC required clearances no greater than, the Broadband Accessibility Act adopted the NESC requirements, and that we had no ability to require anything more than that. And therefore, we were denying them access that was allowed under the Broadband Accessibility Act. We understood that to be their contention. But in our view, that was part of their argument under the code section that they brought the case under. It's right there in the caption. It's 3030A to set just and reasonable terms for a pole attachment agreement. There was no argument that, and one of it, that part is prospective, as I tried to explain to Commissioner Powers. A new agreement under 3030A, a new agreement is to be negotiated, and we needed the Commission's assistance. That's what they asked for. So, and that's what we litigated. 3030B2 is your existing agreement prevents us from attaching. You're not allowing us to get on your poles. And that That issue was not presented to the commission. It's a different issue, and it's inconsistent with the facts. Their view is, I assume that they don't say we're denied access. They're saying they're going forward, that our clearance requirements deny access that they were entitled to under the Broadband Accessibility Act, which was adopted in 2020. So B2 would be looking back at the contract that was adopted in 2004, in our view.
Okay, so what about now? I mean, was there the new contract? Was there ever a request from Spectrum to attach at the NESC minimum?
It's my understanding that Spectrum complied with, in its poll application, Spectrum complied with the existing agreement that was in place between the parties, which had the 84-inch and the 18 feet.
Okay.
And those were processed and approved routinely, as long as they met those clearances.
Okay. So the contract that's up or that's being negotiated now, my understanding, the reason why we're here, there was never a request made to attach at the NESC minimum standard.
I'm unaware of anything in the record that addressed that, where Charter submitted some knowing that they were inconsistent with the poll attachment agreement, but trying to make the point that they thought they had the, and I don't think the Broadband Accessibility Act allows a communication service provider to say, we're going to ignore the existing contract, and here are a set of applications for attachments that are consistent with the Broadband Accessibility Act, and you have to process them and allow us to attach. They did not do that. What they did instead was they asked this commission to set just and reasonable terms for a new contract going forward, and they argued in support of that request that the NESC requirements, the 40-inch and the 15.5 feet, were required, and that York could not, as a matter of law, require anything different from those provisions. We pushed back on that in our view and in our pleadings, and they've made a point of our pleadings. We said that what the statute requires is that the electric cooperative allow attachments at just and reasonable terms. What y'all can do in this case, in an order that we ask you to issue, is to clarify this is how we're going to deal with applying the just and reasonable standard. We're going to start with the NESC, and then we're going to ask the cooperative to explain why it has decided to require greater clearances than the NESC. And I don't think that's very different from what I read in their petitions in opposition to our petition for reconsideration. They didn't address in their responses our request for clarification, but it sounded to me as if we weren't that far apart on that.
Okay, thank you for that. Let's go through the trilogy because of B2. If I'm remembering correctly, a request to attach may only be denied for capacity, or safety, reliability, and generally applicable engineering standards. I think your argument there, well, could you flesh that argument out for me?
Thank you. In our view, an issue arising under 3030A, which says that the cooperative has to allow attachments on just and reasonable terms, is just and reasonable is a somewhat ambiguous term. I think that if the commission decides we're going to look to other provisions of the act to guide us in determining what's just and reasonable. And I think if you say we're going to look to 3030B2 and we're going to look at capacity reasons and safety and reliability and generally applicable engineering principles, that would be a reasonable reading or a reasonable way of guiding your application of the rather broad, just and reasonable standard of 3030A. That's what we think reading the order that y'all, at least portions of the order seem to be consistent with that interpretation. At other times, in our view, the order made a finding of a violation under B2, and I'm not going to go back over that, we think. And there's also a concern to us that there are portions of the order where the majority opinion adopts the charter and AT&T approach that basically says you can't require anything beyond the NESC standards. And that we think conflicts with the 7-person holding that the BAA did not adopt the NESC standards as maximums.
Understood. I was focusing more on whether or not safety, reliability, and generally applicable engineering principles needed to exist together in order to deny, or whether or not it could be an issue of safety alone or issue of reliability alone.
I think it has to be, it could be safety or reliability alone. Absolutely. And I think it's, to some degree, it's a case-by-case determination. If you've got attachments that present significant safety issues, I can't imagine that we're going to want the co-op to allow that attachment because it can't also show reliability and generally applicable engineering principles. It just doesn't seem to make sense. So use those things as a guide for applying just and reasonable, but don't be so, I would say use them when you're using them as a guide, you don't have to worry about whether you apply them all. We're going to evaluate it on a case-by-case basis. This is what we're going to look at in determining just and reasonable. The General Assembly deliberately used the broad term just and reasonable for the terms and conditions that this commission is supposed to apply. Y'all give us some guidance with your ruling in this case. I think that will be taken to heart by the parties and will be used and will guide us going forward. So I think by listing all of those things and not putting more weight on one or the other or requiring that every one of them, and remember that the capacity is separated with the or. So,
well, and it's interesting you make that distinction because I agree with you. Capacity is separated with or, but safety, reliability, and general applicable engineering principles, they're connected with and.
Right.
So, I mean, we would have to be consistent in our interpretation, I would imagine. When interpreting how the conjunctions.
But keep in mind, under my interpretation, what I'm suggesting is you're trying to apply just and reasonable. You're looking to another place of the statute and you're finding the things that the General Assembly said are considerations that apply when a communication service provider is trying to attach to a pole. I think you can look at those things. I just can't imagine that a co-op had a compelling case that the attachments that were proposed would reduce reliability, and yet for some reason there wasn't also a safety element to it that we would say, no, that's not just and reasonable. I just don't think that would be a reasonable interpretation of the statute. And remember, you're actually interpreting 3030A. You're looking to provisions of 3030B2 to help you apply that. So I don't think you have to pay as much attention to the conjunctive, disjunctive, or, and. I don't think you need to do that. I think you can look at those considerations and apply them.
Thank you, sir. And so my last question, just to be clear, the situation that is anticipated by B2, 3030 B2, a request can only be denied. That situation, based on what I'm understanding from you, has not happened in this case.
My recollection of what's in the record is there were no applications submitted at the NESC level that were turned down.
All right.
Now, I think they submitted applications that were consistent with the existing agreement. So they may have wanted to make more attachments at the different clearances and may have decided not to do it, but they didn't submit those applications. There wasn't any testimony that I remember from the record where yes, we submitted applications and they were turned down because they were at those levels.
Thank you, sir.
Thank you.
That's all I have, Madam Chair.
Commissioners, further questions? Commissioner Carolee Williams.
Thank you. I found your discussion about pole attachment bonds interesting, and you mentioned as a potential solution. You mentioned that they weren't being used widely in South Carolina, but they were being used elsewhere. Can you expand on that? Where else are they being used?
I don't know.
I appreciate the honesty.
I have more to say.
Okay.
My colleague, Mr. McDonald, talked to a representative of a bonding company that sells those and procures those, and he said that they've been very successful, very popular in some places. Of course, he wants to do the business. I just presented that as I wanted y'all to be aware of that, and wanted you to be aware that York is approaching this in good faith to try to get to an agreement, to try to find a way of addressing in the contract the concerns that York has, which are very real, legitimate concerns about being reimbursed for costs that they're supposed to be reimbursed for. So that's why we bring up the pole attachment bonds.
And is it your opinion that that would be a permissible tool, a legally appropriate tool?
Well, we have not discussed this with our friends at Charter.
Okay.
We believe that it would be a reasonable, appropriate term to include in a pole attachment agreement. Potentially, ultimately, if they don't agree and we can't work that out or something else, it would come back to y'all. And we would much, of course, prefer not to do that, but it's an example of mostly wanted y'all to know we're working on it and we're trying to come up with something that would be an alternative approach that would acknowledge the concern of this commission that we not get in the way of deployment of broadband in rural areas, which of course is not at all what York Electric Cooperative wants to happen.
Thank you. I appreciate it.
Thank you.
Commissioners, any other questions? Commissioner Justin
I'm sorry,
Williams?
Madam Chair, I have one more question, and you didn't really talk about this much in your petition, but just wanted to ask, what is your opinion on cost in this case? There's some thought that costs were not really presented for our consideration. Do you agree that costs should not be considered at all in this case? Any costs?
The make-ready costs?
Any costs at all, those included, make ready.
Well, I think under the rubric of just and reasonable terms and conditions, I think, yes, costs are a legitimate thing for the commission to consider. And the way I read your majority opinion is that the York clearance requirements were added additional costs to the operations of communication service providers, and that was a factor in determining that y'all didn't think that those clearance requirements were just and reasonable. So I think cost is necessarily an element.
Thank you, sir.
Commissioners, any further questions? Mr. Elby, I have a couple of questions. Commissioner Urban?
Thank you. Mr. Ellerby, to follow up on Commissioner Justin Williams' question, would you also agree that pole replacement costs factor into what constitutes just and reasonable terms?
The cost of replacing poles would be in that category of costs that I just discussed with Commissioner Williams. Yes, sir.
So we're really talking about all costs have to be considered really before we can decide whether it's just and reasonable. Do you agree?
Well, the costs are an element of what's just and reasonable. Yes, sir.
Thank you. And just to follow up on that, I'm hoping in your negotiations, you've talked about pole costs as well.
Yes, sir. Yes, sir. That certainly is an underlying consideration of any discussions. Both, you know, the communication service provider is trying to attach at the lowest cost they can. We understand that. York is trying to make sure that its operations and its service to its members is done at the lowest cost, and that it not be subsidizing the operation of a communication service provider that doesn't pay the make-ready costs that are required. So absolutely, costs are on both sides are an issue.
Well, and are you aware that other jurisdictions have come up with various formulas to arrive at what is a fair, just, and reasonable pole replacement cost?
Well, yes, the FCC requires its actual cost. Nobody suggests that if a communication service provider has to pay costs of replacing a pole, and it decides, yes, we need to replace that pole, and we understand we have to pay for it, and we're going to pay for it, that what they pay is the cost of replacing the pole, the actual cost.
Well, it is my understanding that you would also take into consideration the remaining useful life of the pole that's being replaced. For example, if you have to get a taller pole because of additional attachments, the company's had the use and benefit of that pole for certain number of years. It wouldn't be fair to shift the cost of a brand new pole to the broadband providers, would it?
Actually, Commissioner, that is a question that's currently being considered by the Federal Communication Commission, and they have not, so far, they're still working on it, but so far they have not agreed with the arguments you just described.
Well, it's been been discussed in various legal literature. I know because I've seen it discussed. And if we're going to be fair, just, and reasonable, it seems to me to make sense to take into account, how long has that pole been in use by the co-op? If it's the useful life of the pole is 40 years, and they've used it for 35, it's going to have to be replaced in 5 years anyway. So wouldn't it be only fair that you'd use a formula like that to arrive at what the broadband provider is going to have to pay?
Well, thus far, that argument has not carried the day at the Federal Communications Commission. The contrary argument is that pole could last for many, many years in the future in rural parts of South Carolina if the a pole that's been there a long time, but still has, and may be fully depreciated, but still has plenty of useful life and can provide reliable electric service to the co-op members. From our standpoint, it is unfair to those co-op members for them to have to pay the cost of replacing that pole so that a communication service provider can come in and provide for-profit broadband. But of course, that's far beyond the issues in this case, Commissioner Irvin.
Thank you. No further questions, Madam Chair.
Commissioners, any further questions? I'm gonna wait. Thank you. Thank you, Mr. Ellerby. Appreciate your argument.
Thank you, Chair.
South Carolina Telephone Coalition, Mr. Wright.
Madam Chair and members of the commission, again, my name is Brad Wright. I'm here on behalf of the South Carolina Telephone Coalition, joined by my co-counsel, Peg Fox. Just at the outset, just a reminder that the South Carolina Telephone Coalition is a group of rural telephone companies located across South Carolina. I know broadband's been a popular discussion, especially since the outset of COVID, but these companies have been in the broadband business for decades. They've been extending broadband, especially in rural areas and in their territories for decades around the state. So we still have a rural problem to address, but there are companies that are working on it, and these companies have been working on it for a long time. Indeed, without their services, we'd be in a much worse shape than we're currently in. I want to say at the outset, I want to thank the PSC for taking this action, taking this hearing today. This involves the Broadband Accessibility Act, obviously, which is a statute that's passed in September of 2020, and this is a case of first impression under that act. It's clear that the commission wants to get this right, and I think that's important. And we want the commission to get it right because it has broad aspects beyond just the issues that are being addressed today between York and Charter, because the rules of the Broadband Accessibility Act, they don't just apply in unserved areas. They don't just apply to York Electric Cooperative. They apply to all the electric cooperatives throughout the state, and they apply in areas that are both served and unserved. And so chief among the concerns that we have are competitiveness concerns as well, which are also encouraged. That efficiency is encouraged by the Broadband Accessibility Act. I want to take just a minute and talk about the general purposes. Just a reminder of the Broadband Accessibility Act. I think the context and the history are important, and perhaps get to this a little bit to this question about B2 that the commission was just discussing with Mr. Ellerby. So the Broadband Accessibility Act started out well before the discussions about it. This started well before September of 2020, at least a year before September of 2020. With
Mr. Wright, can I ask you to pull that microphone a little bit closer?
Yes, ma'am. I apologize. Is that
I'm
better?
having a little trouble hearing you.
I have a tendency to back away, and that's my fault, Madam Chair. I apologize. So the discussions over the Broadband Accessibility Act between the providers and the electric cooperatives started well before September of 2020. And originally, those discussions began because the electric cooperatives approached the providers to let them know that they wanted their members to have broadband service. And they were thinking, at least a number of them were thinking about potentially getting into the broadband business itself. Of course, as providers, we're arm in arm with Charter, with the petitioner here, concerned about certain competitiveness issues. If electric cooperatives are getting in the broadband business, we need protections to make sure, among other things, that the electric cooperative, monopoly electric business isn't used to subsidize the broadband business and create competitive concerns. The electric cooperatives conceded to a number of those protections which are in the Broadband Accessibility Act, and we're appreciative of that. It provides us comfort when they are in this business. At the same time, what the electric cooperatives agreed to do at the request of the providers is to agree to certain concessions, particularly access to poles, which is what we're looking at here, access to poles, rights-of-way easements, access that will make it easier for providers to provide service. And so those are the provisions that you see, particularly in subsection B1 and 2 of the Broadband Accessibility Act. So just a reminder, when this petition started out, it was a limited legal question proposed by the petitioner, just as to whether an electric cooperative pole owner may deny access to its poles based on construction requirements that exceed those of the National Electric Safety Code. That was the limited legal question that was put before the commission. And we have some concerns over the way that question was even asked, because it assumes that there's some sort of denial of access, and that seems to be part of our consternation. I know I know now that York has expressed their consternation with the order over this assumption that there's a denial of access. But when Charter asked the commission to analyze this question, they asked the commission to analyze it under 58-9-3030A. That's how the commission was brought. It was brought under 58-9-3030A. And the language, the particular language that was a cause for concern or that was raised by the petitioners was, and I'm quoting, "Access includes the right to non-discriminatory use of all easements and rights-of-way and to all poles, ducts, conduits, to the extent not prohibited by the National Electric Safety Code." So I don't want to beat this to death. I know we talked about it at the hearing. The application of and the interpretation in the majority's finding we find to be a bit conflicting, but the ultimate answer here by all 7 commissioners in both the majority opinion and the dissenting opinion was that that language is interpreted that the National Electric Safety Code is a minimum standard. It is not a maximum standard, and thus, we think that was the correct correct decision, and applaud the commission for unanimously and correctly coming to that conclusion. That would have answered the petitioner's question. That would have answered the limited legal question that was before the commission, and the commission could have stopped there. In particular, when we get into the order, again, our concerns all revolve around this denial of access notion. But the particular findings and conclusions that are troubling to us, I'll start with finding 7 of the order. Finding 7 states that Charter was effectively denied access to York's poles when York declined to allow Charter to attach at the NESC pole attachment standard. The NESC pole attachment standard of 40 inches at the CWSZ and 15.5 feet at the midspan. So despite the fact that the majority opinion has said that the NESC standard is not the standard, it's a minimum standard, it's sort of establishing it as the minimum standard in its order. And we think that finding 7 is flawed for 2 particular reasons. First, the assumption that Charter has denied access to its poles, or that Charter was denied access to York's poles. The evidence in the record reflects that Charter was offered access at the same height and distance requirements that other providers were offered access, and indeed that Charter had enjoyed access all the way back to its agreement with York in 2004. So Charter had access prior to the petition being filed. During the hearing, they were enjoying the access at those heights and distances, the same access that all the other providers were enjoying, and they were providing services at those heights and distances at the time of the hearing. The commission also, that particular finding 7 also references, as I said before, this notion of an NESC pole attachment standard, and we find that conflicts with the statement on page 22 of the order. And that statement says that the BAA does not refer to the NESC standard as a single standard, a maximum standard, or a binding standard, nor is there any stated obligation placed on electric cooperatives in that regard. It is well-settled case law in South Carolina that the NESC standards are minimum standards, and then there are multiple cites to the Supreme Court. So we are acknowledging, the commission acknowledges this as a minimum standard. The commission acknowledges that the Supreme Court has looked at this and the NESC standard is a minimum standard, but yet in its application, it's essentially you must give access at the NESC standard, or you better have some reason and they've gone to B2, which is the next place I go, to deviate from that standard. So the effect of that is that the NESC standard is the standard for attachment, and I think I thought that's what all 7 commissioners were agreeing wasn't actually the case under South Carolina law. I'd point out one other thing in relation to this. We've been very focused on attachment at the NESC level, right? But just and reasonable and non-discriminatory is more than just about where you attach or the NESC standard. This dispute could have very easily been over pole attachment costs or rates, right? And so let's take that example and break it down for a second. If Charter had come to York and said, and the evidence in the record also reflects that they had, I believe, that they had resolved all other issues other than the level or height of attachment and the distance. But let's say that Charter had come to York and said, we want to attach to your poles. We'll agree to the 84 and the 18, but we've been paying a price, and I'm making this up out of whole cloth. We've been paying a price of $10 per attachment. Now we want to pay a price of $5 per attachment because we just think that's fair, part of the negotiation. Well, the problem would have been that Charter's been paying $10 in their current agreement. All other providers are paying $10 in their agreement. You're now putting York in the untenable situation that they could be discriminating and violating the BAA simply by offering Charter a better deal. And I would assert that it's really no different when you analyze the NESC standards and their application here than if you were looking for a better deal on you could have gotten to make-ready costs over a price analysis just as easily as you got there, a pole attachment rate analysis, just as easily as you can get there over NESC attachment analysis. The second part that is concerning to us, again, deals with this denial of access, and that's in finding 8 and conclusion 4, and this relates to the B2 standard. And as I said before at the outset, and I do think context is important here, and I'm just going to tell you what our view was of B2 when we were negotiating the Broadband Accessibility Act. So just and reasonable was the standard in A. B dealt with make-ready timelines, etc. B1 applies make-ready timelines as provided under FCC rules as of the date and time that, and it's actually specifically referenced in B1. So it adopts FCC rules as to access. It does not say anything further about covering make-ready costs. It was extremely important to providers back at the time of the negotiation of the Broadband Accessibility Act that if electric cooperatives were going to be in the broadband business, they couldn't also control all the poles and all the easements. We all needed access to those, and we certainly didn't want to have a competitor that controlled them. So that was the reason that in my view, of why the electric cooperatives agreed to certain concessions to make sure that providers had access. And that's the reason, in my view, the standard in B2 was intended to apply. It's a very high standard, very strict standard. I'll read it to you. Risk of boring you, but I'll read it to you. A request to utilize poles, ducts, or conduits under this section may be denied only if there is insufficient capacity or for reasons of safety, reliability, and generally applicable engineering principles. And those limitations cannot be remedied by rearranging, expanding, or otherwise re-engineering the facilities. It was intended to say the only time you can't give us access, the only time you can't give us access is if you meet this high burden. It's not intended to apply to a standard in subsection A, which has just and reasonable and non-discriminatory, has a whole lot of other factors, price being one, that you could consider other than that limited standard, that very strong, high standard in B2, which is a standard that says if you can't provide us access, it better be because you can't provide us access, not because you need a new pole or not because it can't be done. And that is how we have viewed B2. The last thing I'll address is really the competitiveness concerns. And I touched on this earlier, but again, while the BAA encourages extending access to unserved area, its rules apply to both served and unserved areas. So it's important that the BAA be interpreted in a way not to harm existing investment. And to that end, the commission ruling gives charter access at the NESC minimum standards. It does. And this means they will have better access than existing providers have under their current pole attachment agreements, which leaves us at a place where we don't know, is that actually a violation of the BAA? Are you now discriminating against existing pole attachers because charter will have better access to poles than the 18 and 84 that exists under the current pole attachment agreement with other providers? The other part is the commission order states it's not addressing make-ready costs, and that the terms of 58-9-3030B are not before the commission. It's a little concerning because B2 is what's referenced as the standard that's using to measure just and reasonable, and I've explained why we don't think that works. But it's also clear that while the commission says it's not considering make-ready costs, the order itself acknowledges that it's fashioned in a way to minimize charter's make-ready costs. We find that is inconsistent and potentially dangerous. Again, considering that this doesn't just apply, you can't assume that the areas they're going to serve are areas that don't have fiber already attached to the poles or fiber already buried in the ground and aren't areas that are already served, that now makes it cheaper for them to build over the top and compete with that existing infrastructure. So in conclusion, what I would say is that, one, the commission answered the single limited legal question that the petitioner brought before it, and the commission could have stopped there. If the commission feels the need to continue to move forward on that front and make a determination about those heights and distances, it's certainly within their prerogative to do so. But we would say that there is a lot of room between 18 and 84 and 15 and a half and 40, and hopefully these parties would be willing to resolve that. So the commission could certainly find that the 18 and 84 is unreasonable and send these parties back to continue to negotiate in a manner that allows the electric co-op to consider not only how they can bring that particular instance to a close and to some sort of solution, but what that impact will have on other providers and what access they need to give those other providers to remain in compliance with the BAA. And the last request I would have is that and really extremely important to us, is that if there is a conclusion, we would ask that you withdraw any notion that charter has been denied access to these poles. We just don't think that would stand scrutiny, given that they are on these poles and they are providing service while having access to these poles. So we'd like to see that come out of the order. Thank you, Madam Chair.
Thank you, Mr. Wright. Questions for Mr. Wright? Commissioner Justin Williams?
Thank you, Madam Chair. Good afternoon, Attorney Wright. When you say that the commission could have stopped with answering the legal question, are you insinuating that the majority opinion erred by doing more than that?
No, I think it was perfectly within. So that's a great question, Commissioner Williams. And what actually happened here was that was the limited legal question procedurally, as I viewed it, put forth by the petitioner. The commission could have stopped there, but the respondent, York Electric, did make an argument that, hey, we want you to consider all factors of a just and reasonable determination. And so they made their arguments for why those distances and heights, why they thought they were just and reasonable under the Broadband Accessibility Act. As part of that process, I do believe it was before this commission to make a determination of your own accord as to whether or not you thought those distances and heights were just and reasonable.
I appreciate you making that acknowledgement, and just to add a little bit of levity to all of this, I'm sure TCU wished that Georgia would have stopped scoring in this second quarter, or maybe even the third quarter, but I appreciate that acknowledgement. that it was before us. Regarding the competition piece, is there anything preventing your clients from bringing a similar action that Charter brought? When you say that the commission's ruling, the majority ruling may be discriminatory or may interfere with competition, what prevents another communication service provider from using the same approach that Charter has used here?
Certainly, our clients, our members, could avail themselves of the commission in regards to their rights under the Broadband Accessibility Act, but that may not be particularly helpful if you've already made a decision to invest. So if you've already extended, let's say, for example, I've made the decision that I don't want to, and a lot of our companies do bury a majority of their fiber. Long term, short term it's more expensive to put in, but long term the maintenance costs can be lower. So if I've made a determination that I don't want to pay the make ready and pole replacement costs that would go into place to go serve that area, so I'm just going to go bury the fiber, I've already done it. I've already made that investment. There's no way to avail myself of the commission to try to recover that investment when Charter builds over the top of me, not having to pay those same costs that were part of my consideration for why I went there.
Well, isn't that just a natural consequence of when the law changes, not just in this area, but in other areas? Laws change, situations change that may create what some may perceive as inherent inequity or unfairness?
Well, certainly laws change, and they can create inequity and unfairness. But I think in this context, I don't see a clear notion that they have a right to have access to the poles at those heights and distances at the NESC minimum. I don't see it that way. And it's very important to us that the Broadband Accessibility Act, just like it is to you, Commissioner, the Broadband Accessibility Act be accurately interpreted. But the issue here is that because it applies to both served and unserved areas, I can understand some I don't know the right word I'm looking for, but I can understand the efforts, maybe even to the extent that they harm competition, to get to unserved areas, to areas that don't have that investment. But the Broadband Accessibility Act, if you look at the findings, is very careful about preserving the investment that it's made and protecting competition. And so an interpretation by this body that allows to harm that existing investment by providers, I don't think that's what was intended by the BAA.
Okay. When you say that access wasn't denied, I got one more question after this one.
Sure.
If a new contract is being negotiated and a broadband service provider, in this case, Charter, requests access at the NESC standard based on their interpretation of the BAA, and that access is denied based on whatever reason or rationale a co-op wants to use, whether it's safety, reliability, or all the reasons listed in B2, if they don't provide that access at the NESC standard, is that not a denial?
Well, there are a couple of assumptions made there, right? The first assumption is that it's a proper reading of the BAA to think that it gives them access at the NESC standard. Mm-hmm. And I don't think that's clear at all. I think that, in fact, I think it's clear that it was intended to just serve as a minimum standard to protect from the dangers of if you violate. In other words, the electric co-op is saying you can't force us to violate the NESC. But the inverse of that is not necessarily true, that you can force us to give you access right at the NESC minimum level. And you know what? We've seen language that's come up in other jurisdictions, and it was actually cited in the minority's opinion. It was in our brief to the commission. But we've seen language. I mean, Georgia had language that said, not require compliance by a communication service provider with utility pole attachment specifications that exceed the specifications in the National Electric Safety Code. If the language in the BAA said that, it would be access at the NESC minimum level. But the language in the Broadband Accessibility Act doesn't say that, and this language also, it was part of a proposed amendment in Georgia to their Broadband Act, and it was rejected there as well.
Right. I understand that. But what I'm asking you, though, is if that's the way that it was interpreted, and whether it's Charter or any other communication service, broadband communication service provider interpreted the BAA in that way, and access was denied, whether rightfully or so or not, how is that not a denial?
I think you could interpret it that way. I think that's a dangerous interpretation to assert that that here I am, electric cooperative, and I am making the poles available to you at the same height and distance, the same term and condition that you have had enjoyed since the early 2000s, since 2004 in Charter's case. And somehow this language in the BAA, which I do not think is clear, that it creates and the majority opinion acknowledges that the NESD standard is not a maximum standard, it is a minimum standard. I think it's dangerous to say that when I've offered you exactly what you've enjoyed and been serving to customers, suddenly that's a denial. It's a negotiation. I don't think it would have been a denial had Charter come and said, we want access to these poles at $5 per pole. That's what we want. I know we've been paying 15, but we want 5. And if you don't give us 5, then we're denied. I think that's a dangerous interpretation of the BAA.
Maybe for your, the folks you represent, it may be dangerous for them. I'm not really sure whether it's dangerous or not, but you agree that it could be construed as a denial.
So
you just think it's a dangerous position.
Well, I don't read the BAA that way. And I would say there are other facts and circumstances based on whether or not they made applications to get on those poles that I don't have knowledge of. And Mr. Ellerby touched on that. But I would definitely encourage the commission to be cautious about interpretations that could do damage to existing investment. And that's an acknowledgement in the findings of the BAA.
Now, we use a couple of hypotheticals here. York is the co-op before us, but there are co-ops throughout the state.
Yes, sir.
There's nothing to say that all co-ops exceed the NESC standard, is there?
I'm not sure I'm following.
York is the co-op that's before us, and we
Yes,
know what was in their legacy contracts. We know the height requirements that they asked for in their legacy contracts. But let's just say Williams, hopefully there's not a Williams co-op or Justin co-op.
Santee Electric co-op. Let's go with that
some
one.
co-op. Their clearance requirements track with the NESC, hypothetically.
Okay.
Do you take issue with that?
No, I do not take issue with that.
Okay.
And especially given if they've had a history of providing access at those levels. I don't think that does harm to existing investment. Our clients, to the extent that they're already on that pole, they're on that pole and abiding by that NESC standard. And no one's coming in behind them with a better, cheaper method to serve it in a served area. So no, we would not object to other electric cooperatives offering access at the NESC standard. It's just the harm that could be done to existing investment when I've already extended service out there and now somebody gets to come in behind me to a served area at a better standard than I had access to.
All right. Thank you so much.
Thank you.
One last question.
Yes, sir.
Do you think any cost should be considered in this case? Whether it's make ready or you reference $5 to access poles? Because I didn't hear much. I mean, cost was stated loosely, but I don't remember hearing any evidence about actual numbers.
Yeah, so I appreciate that question as well. It highlights something that, from a context perspective, the negotiations under the BAA, there were efforts at the time of negotiation to try to get the electric cooperatives to agree to the FCC formula on pole attachment rates, on costs, the $5. It's not $5, I can promise you that, but the $5. And those negotiations didn't get anywhere. And I think there would have been winners and losers there. Some of those rates would have been higher, some of them would have been lower, depending on the electric cooperative. And ultimately what we came to was it would have to be just and reasonable, non-discriminatory in subsection A. It was
Who would
really more
determine
of a
that?
price.
Wouldn't the commission determine that?
Yes, sir. And so cost is definitely under that subsection A, particularly for pole attachment rates, would be a consideration. Yes, sir.
But there's no financial evidence in this case that could help us, or at least, well, you tell me, is there any financial evidence on cost presented in this case to help us make a determination based on cost? To make any determination based on cost?
This is a good question, Mr. Williams. Off the top of my head, I can't recall the entire record, whether I could say that there was something in the record to help you with cost. And I recognize that just and reasonable is a pretty broad standard, right? It's a pretty broad standard that's left to this commission to make the determination.
But the BAA does allow any party to, if they wanted the commission to make a determination based on the costs and determine whether or not whatever costs presented or whether costs were at issue, to determine whether or not they were just and reasonable, the commission is a venue for relief there, is it not?
Yeah, I agree with that. But I would classify it this way a little bit. So maybe just a little bit of a difference here is that if you're talking about make-ready costs was heavily negotiated, and we tried to address as much as we could get out of the electric co-ops on make-ready costs in subsection B, which is not before the commission. And what we got was FCC rules related to timelines and requirements of getting on those poles. And then we got B2, which said, hey, if you can't deny us access unless you got to show you really can't get us on that pole. So I have never thought and still don't think, subject to going back and looking at the act again, that make-ready costs were part of the consideration under just and reasonable.
Okay. So when you, and I promise this is my last question. So when you say really make a showing, I noticed in your filing that you really didn't take a position on whether or not York made a showing that their clearance requirements were for safety, reliability, or generally applicable engineering principles.
That's true, and I think that's a determination for the commission, and it's a fact-specific circumstance. And I certainly recognize that 84 and 18 is 18's. That's a pretty big disparity from the NESC. The NESC and the base by which we determine every attachment, but I understand that there's disparity there. And if the commission determined that those were unjust or unreasonable, I'd say I understand that, and that was a negotiation and determination between these two parties. I don't have enough evidence to offer anything related to whether or not those standards are just and reasonable, but I would just say that if you were going to make that determination, send it back to the parties and tell them 18 is not reasonable, 84 is not reasonable. It's got to be somewhere between there, the NESC. Y'all go figure it out.
All right. Thank you, sir.
Thank you.
Commissioners, further questions for Mr. Wright? Commissioner Caston?
Madam Chair, if I may, Mr. Wright.
Yes, sir.
I actually thought I was going to sit here and ask nothing and say nothing, but all the swirling.
I hope I didn't cause that, Mr. Commissioner.
No. In the discussion about cost and make ready and minimums and maximums, it kind of all gets in a big ball. When I think of just and reasonable terms and conditions, is that cost? And before you answer, my I guess real question is, you're right, just and reasonable terms and conditions is pretty broad. Is that necessarily cost?
It's not just cost, I don't think. I think it could be things beyond cost. But that highlights sort of what I was getting at. I used the $5 analysis earlier. But how I would have viewed this being applicable was if Charter had come in and said, we want access and we're going to negotiate this pole attachment agreement. We want the same rate we've been getting. We want $10 per pole. That's the rate we've been getting. We want $10 per pole. And York had come in and said, nope, sorry, for you guys, it's going to be $25 per pole. then I think they come before this commission and say, that's not just and reasonable, and it's discriminatory because other providers are getting a better deal. And that's way overcharging us, and it's going to increase our costs substantially to go serve these areas, and it's way more than we've been paying. That, I think, would have potentially been a violation. It would have been a violation of the BAA. It would have discriminated, and it would have been such a huge cost variance that at least there would have been a burden, I think, on the electric cooperative to come in and say, no, they're $25, and the reason they're $25 is this, and they better justify it.
Okay, and what I'm trying to understand based on the questions that have been asked back and forth from you and Mr. Ellaby in the responses is just and reasonable terms and conditions and make ready cost. Those two different things.
That's how I view the act to be read. Make ready was addressed under B. Just and reasonable was addressed, is in subsection A. It was intended to include costs. I've always thought make ready costs were covered, or make ready requirements were covered under subsection B1, which says you get access at the same requirements of the FCC rules as of a certain date. And that certain date escapes me, but that's how I thought of how I have thought of it.
All right, thank you very much.
Yes, sir.
Further questions of Mr. Wright?
Madam Chair.
Commissioner Irvin?
Mr. Wright, good afternoon. It's good to have you with us.
Thank you.
You recall the testimony and evidence in this record that for a broadband provider to bury their cable in the right-of-way is much more expensive to do so rather than having pole access. You recall that, don't you?
Yes, sir.
So doesn't the Broadband Accessibility Act state that as a matter of public policy, the General Assembly decided that any unserved area of South Carolina should be entitled to broadband accessibility? Isn't that the stated public policy of the act?
It encourages extending broadband to unserved areas, but it also encourages the efficient deployment of broadband facilities in the state, and it encourages the extension to unserved areas in particular. But these rules apply to both unserved and served areas.
Well, do you recall the testimony that York entered into an agreement with Pendium to give them access to serve broadband on their poles? Remember that?
I presume you're asking about the agreement with Comporium?
Comporium, excuse me. I am. I mean, how do you square those two? I mean, when you're looking at what terms are just and reasonable, tell me how you get to how do you square that?
Yeah, so the way I square it is that the Comporium agreement, which isn't properly before this commission, and I believe both the majority and the dissenting opinions agree with that agreement is covered under a different section of the Broadband Accessibility Act, and it has a totally different test, and it's under subsection 3030C of the Broadband Accessibility Act. And I don't know enough about the terms and conditions of the Comporium agreement. I have never seen it. What little bit I found out about it was during the testimony back in September, but it's hard to make an assessment about the fairness of that agreement when it's not before us. And I would assert that the petitioner fully knew and was aware of that agreement, had discussions about that agreement based on the transcript and the record with York Electric Cooperative, and they chose not to address that agreement before this commission.
Well, we heard testimony about the existence of the agreement and some of the terms, as I recall. Isn't that true?
You may have. I also know I objected to the hearing of that, of any part of addressing that agreement before this commission on numerous occasions. And there, I think, is some evidence in the transcript about some general terms of that agreement, but I would assert again, I haven't seen it. I don't have a copy of it. I don't know what those terms are.
Well, and while we're talking about terms, don't you think it's kind of strange that as of fact finder, and the commission also is determining the legislative intent of the Broadband Accessibility Act and its terms, that we were never given the terms that were negotiated or were the details of the negotiations in the underlying conflict. Do you find that strange that we were never provided with the status of the negotiations?
Which negotiations, Commissioner? Are you referring to
Negotiations between York and Charter Spectrum.
Do I find it strange that the commission? I'm sorry.
There's certain details about why the negotiations broke down, as I recall, were never really provided.
I'm not sure that I'm the best person to answer that question, because again, we weren't part of those discussions between Charter and York Electric, and I'm not sure exactly why it broke down, why those discussions broke down. It certainly would have been easier if these two parties could come to some sort of agreement on access to those poles, so that we don't have to be here today.
Well, and I think that's what everybody was hoping would happen before we had to hear the case, but apparently it didn't, and we still don't know quite why it didn't. But just wanted to ask you about that. Thank you, sir.
Thank you, Mr. Commissioner.
Commissioners, further questions? Mr. Wright, sounds like you were involved in the negotiations and the writing or the process of BAA becoming law. Is that correct?
Yes, sir. But I
Yes,
guess,
sir.
I'm sorry, but I was looking at Mr. Willoughby, thinking that
Oh,
that
please
Mr.
don't
Willoughby.
tell me I look like Mr. Willoughby.
Not at all. Not at all. Not at all. Not at all. Both very good-looking people, very different. But Mr. Willoughby and Mr. Ellerby and I were all involved in those negotiations and drafting.
And when you were referencing 330B, or maybe I think it was you, is it your reading of or understanding of the BAA that applies at the time there is an actual application to put? I mean, I don't see the word application anywhere in there. It says authorization, and I'm trying to figure out, would authorization not be at the time that a contract is being negotiated?
Let me look at B. That's a good question.
Thank you. I appreciate it.
Yes, ma'am. You probably weren't looking for that affirmation. It wasn't necessary, but still, it's a good question.
It's a good pause.
I think that I don't see how you would make a determination of denial without some sort of application being made or request to get on the poll. And
Well, if you're trying to get the terms and conditions in a contract, and you're not getting, you're not being denied those terms, that would be at the pole or the pole attachment height, not the pole height, but the attachment height, attachment standards, let's say,
so if you can't agree on the pole height or the
terms of the attachment,
then you have a disagreement.
yes,
Right. If applications have been submitted to get on the polls, perhaps you have a denial.
Well, you wouldn't submit an application until after you have a contract in place, would you?
Well, I don't, I don't know that that's necessarily the case. There is a contract in place between Charter and
I understand that, but that contract was from what, 2000, 2001?
2004, I believe.
Something early 2000s, and BAA came in 2020. So
Yes,
the
ma'am.
landscape changed. With the enactment of the BAA, the landscape changed, did it not?
It did.
Okay. And that's probably what drove them to ask for a new contract. Otherwise they could have just proceeded under the same old thing.
I'm guessing that is what drove them to ask for a new contract.
Okay. But am I correct that you indicated that B applies when there is an application? Is that correct?
Well, I don't know how you would determine there's a denial until an application has been made. But you raise a good point about the negotiation and existence of the contract.
But application is not used there. It says authorization. Is that correct?
It does.
So what is your understanding of authorization?
I would have viewed that as an application before you started asking this line of questioning. That is correct. That you've made a formal request to access the polls, which is my understanding, that's generally what providers do.
But if you have a contract in place, would your application not, to use your word, application, would it not have to conform with the contract you have in place?
That's a better question for some folks who have worked on these poll attachment agreements more extensively than me, but that makes some sense. I think what I would probably highlight about that is that this is a contract negotiation on some level, and so there has to be a reasonable determination. Are you really denying someone access when you're giving them the same access that they've already had? Are you denying someone access when you give them the same price that they've already had? Are you denying them access when they have the same heights and distances and the same price that both they have had and the other providers have had? It creates a potential catch-22 under the BAA, and I think it would have been better capable of being addressed if there was some unreasonable provision that was different than what York had already been providing, or different based on what they had provided or agreed to with other providers. And I think that was the context in place when we were looking when we were working on the Broadband Accessibility Act.
Okay. Thank you, Mr. Wright. I appreciate your comments this afternoon.
Thank you, Madam Chair.
Commissioners, anything further? Okay. Thank you.
Thank you.
We've been going a little over an hour and a half. I need to give the court reporter a little break, so let's see. It's 4:38. Let's come back at 4:50. I'm sorry to delay you, Mr. Willoughby, and everybody, but she's the most important person in the room today, so thank you. 4:50. Good afternoon and welcome back to the Public Service Commission. We are here in oral arguments in docket number 2022-188 EC regarding petitions for reconsideration filed on the Commission's order. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin, and present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Castanen, and Chair Belser. We will now recognize Mr. Willoughby for Spectrum Charter.
Thank you very much, Madam Chair, members of the Commission. Thank you very much for granting us this opportunity to appear before you this afternoon in opposition to the petitions requesting a rehearing, reconsideration, and/or clarification. Let me reserve right at the outset, Madam Chair, that I'm going to make some opening arguments and some points on some of the legal principles, and then my colleague Paul Warner will address some specific questions, and together he and I will answer any questions that any member of the Commission may have. So. I'll stand by. Madam Chair, I did not cause it.
Mr. Willoughby, please go ahead.
Thank you very much. At the very outset, let me assure the Commission that the majority opinion got it right. There is no question that the opinion was faithful to the plain language of the statute. There's no question that the Commission answered correctly the issue that was presented to the Commission. There's a couple of things I want to address before I go directly into some of the information that supports what I just said. You've heard some argument this afternoon that the 2004 agreement gave charter access to polls. Well, the BAA specifically addresses existing agreements, and there's no discrimination between existing agreements that took place before the BAA and agreements after the BAA. In fact, the commission, the majority opinion, directly noted that before the BAA, a company, a communications provider such as Charter, had absolutely no leverage. It was take whatever the cooperative may give you. But the BAA changed all of that. And I would direct the commission's attention to A1 of Section 3030. And all of my references this afternoon, unless I say otherwise, will be to Title 58, Chapter 9, and 30, I think it's 3000 at SEEK. But I'm just going to refer to the last four numbers, the section number. So Section 3030, subsection 1 states, except as expressly provided otherwise, nothing in this article alters, amends, or otherwise affects the provisions of any agreement that, as of the effective date of this article, addresses the attachment or placement of facilities by communication service providers on or in the poles or structures of an electric cooperative. That's referring to the 2004 agreement. In other words, there's nothing in this statute that displaces an agreement that's already in effect. It does not terminate that agreement, does not terminate the terms of that agreement. But then the next section, Section 2, says, notwithstanding Item 1, what I just read, a communication service provider may submit to an electric cooperative a written request to negotiate agreements addressing the attachment or placements of facilities after the date of the request. So once the BAA was passed, then on that day and thereafter, we could tender a request that we want to make new attachments, and then the parties have a choice. They can, and that choice is still under subsection 2, and the co-ops would have this choice. Unless the communication service provider and the electric cooperative agree otherwise, such agreements must not address facilities that were attached or placed prior to the date of the written request. So those attachments that were in place under the 2004 agreement would not necessarily be affected by any new agreement unless the parties agreed that it would do so. So they could have two discrete agreements, one that was in place for existing attachments that occurred before the BAA, and then the agreements after the BAA. What we are here about is a request that was made by Charter for attachments that would be made under the BAA and for a new agreement for new attachments going forward. So that addresses that issue, and there was a fair amount of debate, which I was surprised about trying to argue that there would be discrimination between an old agreement, someone that had already placed facilities on a co-op's poles versus one under a new agreement, and those different terms could create some discrimination. The Act specifically addresses that set of circumstances and allows those poles and attachments, or the attachments that were in place already, to continue under previous agreements if the parties agree. Now, they could agree to allow the new agreement to apply to both, but that was not at issue in this case. There was also some questions raised by Commissioner Irvin, I think, as to whether or not there was any evidence in the record that addressed there being different costs involved, and specifically in the majority opinion, address this in the majority opinion. It pointed out that Charter witness Lupino testified that Charter has already had to lay cable underground at a greater expense than if it had been able to attach to the York poles. According to Mr. Lupino, it did cause more expense. It did cause a delay because we had to re-engineer. And this is on page 24 of the commission's order in this case. So there's no question that delay was at issue, expense was at issue. When you're unable to get the access that you are seeking and you're unable to get it in a timely manner, then you have to sometimes make alternative arrangements, if alternative arrangements are even available to you, but you do so at significant delay, at significant expense, and that evidence was in the record before the commission. I also want to, now I've got a PowerPoint that you should have in front of you. I'm not going to try to go through the PowerPoint in specific detail, but there are some provisions I want to mention to you or show you. Can we put up the, there we go. So bottom line up front, if I can, there was some question, I can't remember who raised this question, was the question of, the argument was made that we didn't have notice. And Commissioner Williams pointed out that he saw the term deny 11 times in the petition. But if you go to the prayer for relief, the prayer for relief says, and I quote, confirm that the BAA prohibits electric cooperatives from denying pole access based on construction standards that exceed the NESC. And that's the charter petition at page 20. Can't be much clearer than that. And then the order addresses that question. Addresses it on a number of occasions. We've quoted here to you order at page 29. Thus, the most reasonable interpretation of the statute is that electric cooperatives cannot deny access based on standards exceed the NESC. And then you state without proper justification. Now, you've had an argument this afternoon saying we just want to sit down with Charter and see if 84 inches is too much, and if 18 feet is too much, maybe 17 and a half might be right. It's the Three Bears story. Mama Bear is too cold, Papa Bear is too warm, Baby Bear is just about right. So we want to sit down and have an argument or debate and negotiation and see if we could get it just right. So clarify your order, commissioners, to give us the opportunity to do that. And of course, you know the underlying subtext of that. Change your order, turn the ball back over to us. We tried to negotiate with them. We've submitted all of that, and I think Commissioner Irwin may have asked this question as well. We presented that all of the terms of the agreement had been agreed to. The only term that was remaining to complete the agreement was the terms related to the NESC standards. And that was the issue that we brought to the commission to provide us with direction. One of the things that I think is so clear and so faithful, and I've had the pleasure of drafting orders at this commission. This was a long time ago, but I've actually drafted orders that the commission has signed. And you're always, when you're a staff member, doing that. You're trying to be very faithful to the directive. I would say whomever the author is of the order that was drafted did a superb job. When you look at the language that was used and employed in the order, it is as faithful to the interpretation of the plain language of the statute as any I've ever seen. And that, of course, is what your statutory construction charge is. The first rule of construction, they teach you that in law school, first rule of construction is the plain language of the statute itself is the best evidence to determine what the General Assembly was trying to decide. And how did the commission look at that? You've got in your order here on page 27, you state as clear as it could be stated, in applying the plain language, no, correction, in applying the plain meaning rule, a communications provider has no right to an attachment that is lower than NESC's above ground clearance requirements because such an attachment is prohibited by the NESC. Reciprocally, we are persuaded that an electric cooperative has no right to deny an attachment that complies with the NESC's 40-inch CWSZ clearance requirements because such an attachment is, quote, not prohibited by the NESC, end quote. And that reference is to SC Code Annotated Section 58-9-3030A. The NESC and the issue that we brought to the Commission's attention for determination addressed the BAA. It did not address all of the arguments have been attempting to say, well, all you got to do is look at 3030A because that's all they raise. That's simply not correct. We raised the BAA, and the issue that we brought to the Commission's attention was the question as to whether or not cooperatives may deny pole access based on construction standards that exceed the NESC under the BAA. Now, I think it is important, and the majority opinion pointed this out on more than one occasion. The public policy is just absolutely so clear here, could not be any clearer. And you find the public policy of the Act under Section 3000. And it says the General Assembly finds that, and there are several findings, but one that is particularly applicable here is subsection 4. It is the public policy of this state to encourage and facilitate the development and investment in broadband facilities in order to facilitate access to broadband services at all locations in the state, as this development is vital and necessary to induce, create, and promote industrial and economic development and to create job opportunities, enhance health care, and enhance educational advancement in the state. That's a very, very strong statement of why we are doing this and why we want it done quickly. It is the public policy of this state to promote the efficient deployment of broadband facilities in the state. And by doing that, their goal was to remove any impediments, remove any delays, and in particular, they've indicated that deploying into rural areas in particular was a major, despite the substantial efforts and billions of dollars invested by existing broadband service providers, locations within the state still lack access to broadband service particularly in rural areas where the cost to deploy facilities is significantly higher than in more densely populated areas. So for all of those reasons, the issue is we want to speed the deployment of broadband. And Mr. Wright was absolutely correct. He and Mr. Ellerby, I, and others, Patrick Turner was very much involved with those discussions as well, and I'm very sorry that Patrick had a death in his family, was unable to be here. And I think he's reported to the commission that that's the very reason that he's not here this afternoon. But we all conferred about the language of this statute, and it's very true that the co-ops wanted certain things. They wanted to be able to get involved in the broadband business, and in doing so, they were restricted against doing so in a fashion that would be anti-competitive, where they gave advantages to their affiliates. So in exchange for them being able to have certain rights, they open up access to their poles and attachments with certain limitations. And the commission was dead on target when you pointed out that the NESC is mentioned 3 times in this statute. And when you look at the language, it's mentioned in 3030A, which you've quoted. It's mentioned in 3030B2, which has been block quoted on a number of occasions. And nobody says anything about this. I don't think anyone mentioned this one time this afternoon. But it's also mentioned on 3030D2, which states a communication service provider that has attached or applied to attach facilities on electric cooperative infrastructure, and the electric cooperative must cooperate with the owner of the pole and all other attaching entities in good faith to fully comply with the National Electric Safety Code requirements for infrastructure attachments. So all of those things come back to the NSC as being a standard. And the standard was very appropriately pointed out by the majority when they mentioned B2, a request to utilize poles, and I'll limit it to poles because that's what we're talking about here, may be, and the words are, may be denied only if there is insufficient capacity, that's one reason, or for reasons of safety, reliability, and generally applicable engineering principles. And then only if those limitations cannot be remedied by rearranging, expanding, and so forth. So the majority got it right. The order is right. The interpretation of the plain language is right. But what you're being requested to do today is you're being requested to retreat. Allow us to go back to the negotiating table. Clarify your opinion. Withdraw this finding of fact, and I think they focus on your finding of fact number 7. Charter was effectively denied access to York's poles when York declined to allow your charter to attach at the NASC pole attachment standard of 40 inches at the CWSZ and 15.5 feet at the midspan. And that's absolutely true. Finding's dead on. Finding is supported by substantial evidence throughout this record. And I think it's also instructive for you to recall that I do find it somewhat amusing that we're here today saying that the commission took a broader look at the evidence when we moved to restrict the scope of the hearing, and they objected, very rightly so, and frankly, at this point in time, I'm glad they did, and I'm glad the commission ruled and said that they could broaden the hearing, they could present whatever evidence they wished to present in support of their positions. And I would also point out, and no one said anything about the comporium until Commissioner Irvin asked that question, but the information about the outline of the comporium deal was presented by Mr. Basra's testimony and an attachment to a testimony that he filed. So they placed that information into the record, and now they wish to retreat from it, apparently for whatever reason. That issue, we did not raise the issue of the discrimination issue. Commission didn't make a finding about the discrimination issue. That's not in the commission's order, but that evidence, I want it clear on this record that that evidence was presented into the record, at least initially, by York's own testimony. We would urge the commission, and then I'm going to turn the podium over to Mr. Werner. We would urge the commission that there, and I do want to review this with you because these are your standards. And I can see it better here than I can there, so if you don't mind, I'll turn this way. The purpose of reconsideration is not to give someone an opportunity to just rehash things. It is to identify and correct specific errors and omissions. I see there has not been the first piece of information submitted to you in any of the petitions or in argument this afternoon, other than Mr. Ellerby did come up with this creative thought that is nowhere in this record. And it just comes out of the blue about this bond thing. And so that's one of those rabbits that Mr. Ellerby wishes to have you chase. So we've got this bond idea. Maybe we can sit down and work something out with them on a bond. And it may well be that there's something there. I don't know. But it's not an issue that's before this commission. It's not an issue that would cause you to change your decision. It is not an issue that talks about a specific error or omission in your order. Nothing has been said here today or filed in the petitions. It is also very clear that the commission's findings are presumptively correct. And so there's nothing that they've indicated to you that would raise the presumption. One of the commissioners asked the question about discretion, and certainly the commission has a certain amount of discretion. But I would argue here that you have interpreted the statute as faithfully as it can be interpreted using the plain language standard. Gets no better than that, and this is a perfect case. It's almost a textbook case of that standard being applied to a statute that's a new statute available for a first impression interpretation. And for someone to overcome the presumption of correctness, they must demonstrate that the commission's findings and conclusions are clearly erroneous in light of the substantial evidence on the record as a whole. And frankly, no one's really talked a lot about evidence and what the record reveals and what the record and how the record supports the main order of the commission. Rather, the urging that's been made to you this afternoon and in the petitions is that why don't you withdraw one or two things and send the parties back to the negotiating table? And of course, you know, you've been doing this way too long. You know that that is nothing more than a delay. It's an effort to create uncertainty and confusion. And we would certainly urge you that there is no justification for doing that or making any other change to your order. And with that, I'm going to turn the podium over to Mr. Warner.
Mr. Warner?
Good afternoon, Madam Chair and Commissioners. Really appreciate this accommodation, and I promise you I will be brief. Just picking up on that bonding piece, there actually was a bond requirement in the old agreement, and there was a bond provision negotiated in the terms that the parties agreed on in discussing a new agreement. But where I'd like to start and just discuss with you briefly is finding number 8, which the petitioners don't challenge. And that finding is really a core part of the order and an important linchpin. And in finding 8, the commission found that York failed to support its pole attachment clearance requirement as necessary for reasons of safety, reliability, and generally applicable engineering principles. What the petitioners do want to talk about is the reference in finding 8 to subsection B2. And there was a lot of discussion around that subsection, and it was pretty wide-ranging, but I'd like to return to that and focus our attention on it, because the key word in B2, which is a freestanding subsection of that subsection of the statute, it refers to a request. That's the critical word that's used. And request has a very clear and obvious definition that we all understand and use every day. A request is an act of asking politely or formally for something. There are a lot of activities that fit within that plain language definition of request, and one of them would be requesting to negotiate a new contract with terms and conditions regarding clearance heights for pole attachments. As you all know, that was requested by charter. It was one of the terms that the parties negotiated, and the parties never reached an agreement that included clearance requirements. And I'm here to tell you, if you don't have a pole attachment agreement, you are not making attachments to any poles. It is not as if you can submit permit applications and just race ahead with attachments if you do not have an agreement. There is not a utility in America that would allow a communications company to attach to any poles without an agreement. And here, there's no dispute among anyone that there was no contract. York refused to agree to a contract that included a term that this commission found, and the petitioners do not challenge, was not justified based on the evidence before the commission. I can also tell you that there was evidence in the record that charter did seek to attach at the NESC requirements as part of the negotiations and part of its builds to rural areas. I'm sure the commission will recall a testimony from Mr. Lupino, and just to remind you, that's at 516 through 518 and 522, where Mr. Lupino was told by York that charter could not attach at the NESC standards, and in fact would instead have to replace a whole lot of poles in order for York to accommodate its attachments. So the bottom line with respect to the request that charter made to attach at the NESC heights was it made the request under the old agreement, which clearly prohibited it. It made a request in the context of build outs to rural communities, rural areas within York service territory, and was denied, and instead was told that it would have to replace all the poles. And it made the request in the context of negotiating a new agreement with York so it could attach at the NEC requirements. In plain English, it made a request and was denied. And it made a request and was denied to attach for reasons other than insufficient capacity, safety, reliability, and generally applicable engineering principles. That's a finding that the petitioners don't even challenge. And just to summarize what my colleague had said earlier, all of the other narrow grounds on which the petitioners seek rehearing or reconsideration or clarification all fundamentally rest on arguments and evidence they presented, and they didn't present anything new or different or provide any basis on which this commission could properly rehear, reconsider, clarify, or correct anything in its order, and it should decline the opportunity to do so. Thank you very much. Happy to answer any questions.
Thank you, Mr. Warner. Commissioners, questions for Mr. Warner or Mr. Willoughby? Vice Chair Powers, excuse me, I saw him first. Casting your
And I guess either one of you could answer this, but same question I had for Mr. Ellaby. Why can't negotiations continue? It's about money. Why can't this, why did it have to stop for this reason, for posturing? Is there any other reason other than posturing your position?
They can go forward. The reason they're not going forward now is because York and SCTC have filed petitions for rehearing, reconsideration, and clarification. Otherwise, Charterstown's ready to negotiate with York and finalize an agreement. That's what it wanted from the beginning, and that's what it sought throughout this proceeding, and it stands ready and is committed to good faith negotiations to reach an agreement.
I just feel like if the minority were the majority, we'd still be here. Do you think today?
Well, that's hard to say, but I can tell you this. We're not negotiating now because York is continuing to litigate. But if York would like to sit down with us and negotiate, we stand ready to do so.
Thank you, sir.
Commissioner Caston.
I just assume both of you are going to be standing up there, but I'll just ask the question, whomever wants to answer it. Do I understand that it's Charter's opinion, and don't let me put words in your mouth, that the BAA trumps Co-op or York Electric, in this case, existing policy?
Yes, if it's inconsistent with the statute, absolutely.
So if it's not inconsistent with the statute, it doesn't trump any policy.
Well, I would say this. If York has terms or conditions that are inconsistent with the statute, those terms would be unlawful. I'm not sure I totally understand what you mean by policy, but of course, the goal of the BAA is to have the parties sit down and negotiate and reach an agreement. Of course, in the context of negotiations, there are always lots of puts and takes and things that get agreed to. So a negotiated agreement would not be inconsistent with the statute, even if perhaps it had a term or condition that maybe standing alone you could challenge.
Well, relative to Mr. Powers' question, I think I heard you say that you'd be negotiating now if we weren't still in litigation or York wasn't still in litigation. Is that correct? Or did I not understand?
We stand ready to negotiate.
I'm sorry?
We stand ready to negotiate now.
Yes, but I thought you said if York would, I guess, if it sounded like if York quit litigating.
That's not what I was saying.
Oh, okay.
No. I wasn't putting any preconditions on it. What I'm saying is we're not currently negotiating because instead of picking up the phone and calling us to sit down and negotiate, York filed a petition for rehearing. That doesn't mean that we can't continue to negotiate, but we're here now today because we're doing this, not negotiating.
Well, who filed the first petition or who filed the first shot over the bow?
We filed the petition that led to the order. Absolutely.
So so that it was not possible to continue negotiating before doing that or going through all the other avenues before you brought it to us? That was your only option?
We had exhausted all of the efforts to negotiate, which is why we filed the petition. If you'll recall, and we put this in the record, the parties had actually negotiated a full agreement with the exception of one provision, and it was a provision around the clearances. So the parties needed clarity on what was required with respect to clearances.
Okay.
That's why the negotiations couldn't have gone on during the course of the proceeding. But now that that has been determined, the parties certainly can negotiate.
But you're not saying that you exhausted all options before you came here.
I am saying that.
When that option that's in the BAA about going to ORS, why did Charter not even consider that?
Because we weren't challenging you mean with respect to the compendium agreement? We weren't challenging, we didn't even know about the compendium agreement. We pursued the statutory mechanism to have a resolution of a disputed term.
You talking about the Comporium agreement? No, that wasn't what I was thinking, but so
We did meet with ORS before we filed our petition up.
So let me
That's what you're
let me ask you this as I think about this, and I'm not, look, everybody's got an opinion, everybody's got a side, I get that. Does Charter have underground communications?
Do you mean, does it use conduits? In some places, yes, it does.
When I think about this and think about some of the questions that's been asked, if York Electric or any electric co-op or some other communication company said, look, under the BAA, we think we can have access to your conduit, provided, you know, the construction standards don't exceed the NESC. Would that be a problem?
I'm not sure I understand. I guess maybe let me clarify my answer. Charter uses conduits, uses other utilities' conduits. Charter does not generally have its own conduits, just like it doesn't have its own poles.
Well, that's what I
you're
was asking you.
Yeah, sorry. So let me
Okay,
rephrase my response.
Well, let me rephrase it.
Okay.
Does Charter run cable underground?
It in reliance on other utilities' conduits. Yes.
So Charter doesn't have direct barrel. You put no cable under the ground. You use everybody
no,
else's
not
stuff.
generally as a
Okay.
not generally as a
So whose conduit do you use?
other utilities generally. There may be places and circumstances where Charter does build its own conduit, but that would be a very limited type of scenario.
Okay, let's just do a hypothetical. Because clearly you like using the other stuff, because I get it. You know, I'd do it too if I could. If Charter had conduits, and you say there are some place it does, or whatever infrastructure they have, whatever infrastructure Charter may have, and the electric co-op or some other communication company wants to use it, provided the construction standards don't exceed the NESC, would Charter have any issues with that?
The honest answer is I don't know. I can't speak for Charter on that.
Okay.
But I think getting back to what I thought you were going to ask me was whether Charter would be mandated by the BAA to provide access, which it would not, because the BAA applies to electric cooperatives, not to communications companies.
That was my other question. I was getting ready to get to that. You answered it. So the BAA was pretty much developed for electric cooperatives, right?
That's true.
But was it developed for electric cooperatives possibly also to get into the broadband business too? But if they did.
There are others in the room who could speak to those negotiations better than I could, but I don't believe that that was part of the statutory purpose, no.
Well, I don't want to sit here and everybody read it again, but I think if you read the first little part there, you sure?
You want to point me to the?
Nope.
I'm looking at
I don't have
subsection
it
A,
in
which
front of
says
me. I can't do it.
an electric cooperative shall provide communication service providers.
Uh, 5893,000 B3,
So,
I guess.
Commissioner, I'm trying to understand the question. Was your question,
I can hear you, no one else can.
Yeah, can you? Was your question, did the BAA provide certain rights to the cooperatives? Was that the question that you were focused on?
Commissioner Caston, can you restate your question, please?
Yes, ma'am. The BAA in the short title legislative finding, section 58-93000, does the BAA, or does the focus appear to be that electric cooperatives are encouraged, allowed, or intended to get into the broadband business?
Well, so the act did have more than one purpose, but the primary purpose of the act, the public policy, was to ensure that broadband is deployed throughout the state and certainly into unserved areas. And one of the ways it did that was requiring the co-ops to open up their rights of way and their poles to attachments, which brings us here today. Also in that act, it did permit co-ops, did not require them, but it gave co-ops the option, if they wanted to deploy broadband themselves in their service areas, and my recollection is maybe up to 2 miles outside their service areas, they would be given a permission to do that. Now, there's a whole certain requirements about making sure that they do it in a way that there's no discrimination, that they're not using the resources, their electric customers' resources, to subsidize it. So there were lots of safeguards in there. But they were given certain rights under the act if they wish to do some broadband deployment of their own.
So if I'm understanding you correctly, it sounds like, I don't think this is what you're saying, but you may be, that the BAA was, it almost sounded like you're saying was developed for communication companies to use the utilities poles rather than equally so, or maybe more so, for the electric co-ops to get into the business also.
Well, one of the primary, there's a lot of issues. One of the things that this act did was there was some concerns by the co-ops about whether or not their poles, their use of poles for putting broadband in their poles would have been beyond the rights of the easements which they had. And so they were given some safeguards in the act. But none of those issues are before you. And I'm trying to answer your question, but at the same time, I'm not sure that I'm fully understanding it. But there is no question that the co-ops were given rights, certain rights, to get into the broadband business under certain limitations and under certain structural arrangements. But they also had this obligation to not deny access to communications service providers such as Charter to their existing rights of ways, poles, conduits, and the like. And that is the issue that we bring to you in this proceeding.
But you're not saying that they had no right to deny it, period. That's not what you're saying.
Well, no, that issue has been addressed. They cannot have standards according to the ruling and according to the law. Mm-hmm. They can't have a standard that exceeds a construction standard that has the effect of denying access, that exceeds the NESC.
Okay.
Except they've got, if there's a lack of capacity or the safety, reliability of generally applicable engineering standards, which the commission determined in this case had not been demonstrated. Business reasons, future business reasons, is not one of the requirements under the Act. And that was the primary reason that was advanced by York in this case to support its justification for having a greater standard. Now, Mr. Ellerby has said, we don't really challenge that finding that the commission, that 84 may be too high and 18 feet may be, or 84 inches may be too much of a internal differential, and that the 18 feet may be too high. But it's my three bears story.
Commissioner Casanova, if I can get back to, I think one point or one question you had was the statute does not provide a reciprocal right for electric cooperatives to access infrastructure of communications companies. I think that's one of the things that you're asking. And I wanted just to tell you why that is. It's because generally speaking, all of the poles, rights of way, conduits are owned by utilities as a function of history, and generally as other requirements for aesthetic reasons, planning reasons, environmental reasons. Generally, other companies aren't allowed to install their own poles or own infrastructure, so there's generally just one set, and is generally owned by the co-ops. That's why the legislator focused on that here in this statute.
That's a lot to cover, and don't take this personally, Mr. Willoughby, but Mr. Warner answers a lot more quickly.
Well, good. I appreciate you pointing that out, Commissioner.
I have the disability of being from the Northeast, so.
All that said, and I understand what you're saying, but I do think, we're in agreement that the BAA does certainly give the electric co-ops the ability to get into it, provided it's done in a fair and equitable way, allowing access and this kind of stuff. Now, along with what you just said, Mr. Warner, I want to make sure I understand that, is, and you actually made the point to the question I was going to ask you, who owns the infrastructure, the poles, the lines?
Right.
The co-op.
Right.
And there is nothing, now, I don't want to contradict you here, but to my understanding, there is nothing to prevent Charter, AT&T, or anyone from setting their own poles and running their own lines. It's a matter of acquiring rights of way, putting in the stuff, and getting all their respective permits. Is that true or false?
Well, you kind of have to look at it at a specific location, but generally speaking, yeah, there generally are prohibitions against that under city codes and county codes and other types of things where you don't generally see multiple lines of poles for that reason.
I agree.
Yeah.
But never mind. I'll leave it there.
Okay.
I don't know that I'm the only engineer in the room, but I feel very uncomfortable because I'm surrounded by attorneys, smart people, all kind of stuff. But, so is safety an engineering question?
I think it is in part an engineering question for sure.
Is reliability an engineering question?
I believe in part, yes.
So when we talk about safety, reliability, and engineering, it almost sounds like, is it all got to be together? Are they all separate, or what's the right answer there?
I agree with Mr. Elleby's point that there's probably some overlap. There may be situations where you might have one and not the other, but generally, if it's not reliable, it may very well not be safe as well. Or if it's not reliable, it may well be because it doesn't follow generally applicable engineering standards and so on. So they certainly are related, and you may have multiple checks in the boxes, you may not.
So I think I understood this. It gets confusing. Does Charter agree that the 40-inch NESC clearance is a minimum standard?
Is a minimum standard? No, it doesn't agree. I mean, it abides by the commission's ruling that it's not the maximum standard.
Okay. So you're not saying that the 40-inch is a minimum standard?
What we presented throughout this proceeding is that it is the standard of safety. It is not a minimum, and the commission, of course, has found that it's not the maximum.
Okay. But it is the standard.
Yes, in the sense that either something's safe or it's not.
Does Charter agree that whether it's York or any electric co-op can exceed, in Charter's view, the NESC standard, which best I can tell is 40 inches, the way I'm hearing it, that the NESC standard is 40 inches. Is that correct? Am I understanding that wrong, or am I just?
If I understand the question, Charter would agree that a utility may exceed the NESC standard for capacity reasons, where there's insufficient capacity, or reasons of safety, reliability, and generally applicable engineering principles as identified in B2 of the BA.
So you agree that an electric cooperative can do that, can exceed that with what you just said?
Where it has been justified by on an appropriate basis, such as capacity.
I'm glad you mentioned that, because kind of give me some examples. What's an appropriate basis? Because apparently what Charter did, what York did, you said wasn't. So what is?
The commission found that what York did wasn't appropriate. But York put forward the basis that it reserved space for its business purposes.
I understand.
What I am saying, and what the commission has held, is that the reasons for departing from the NESC are those identified in B2 of the statute.
Again, I understand that, but I guess what I'm trying to understand is Charter agrees that it can, but I don't know what falls in that category. I mean, you say safety or reliability. What is that? What would be something that may qualify for that? Do you know, or would Charter have an opinion?
If there's a circumstance where attaching at the NESC standard would pose some kind of safety hazard for some reason, a specific example doesn't come immediately to mind, but it would be something like that. Or another reason would be if Charter wanted to attach at the NESC height, but in a way that was not consistent with other engineering practices, for example. If they wanted to put a wire up there and stick it on with bubble gum, for example, or they wanted to hang banners or put fireworks up there or something like that, that would be a reason.
That was a good one. Thank you, Mr. Warner and Mr. Willoughby. The only thing I can say, and I understand it, the praise and eloquence you gave to the majority on how well written theirs was, and you didn't say diddly about the other guy. But thank you. I don't expect it. I'm through. Thank you very much.
Hey, Mr. Commissioner, my mom always taught me that praise and don't criticize if you can avoid criticism. So,
Commissioners, further questions?
I have a very quick question. I just want to understand where you all are in this process, because it seems as if the petitioners are very open and have at least seemingly demonstrate more flexibility now than before, which I guess is understandable. But what I don't understand is the request that we order or request or ask you all to continue negotiations when that's something that you don't need an order or instruction from the commission to engage in. So that's a bit confusing to me.
Yes, Commissioner, I don't think that any order is necessary or required. Charter, for its part, is very eager to get an agreement in place. And as you will recall, this was the only term outstanding. So the parties should be able to ink an agreement tomorrow now that the commission has provided clarity around the clearance requirements. And we would love to be able to do that.
Thank you.
Anything further? Thank you, Mr. Warner and Mr. Willoughby. Brief, ORS, anything?
Nothing, Madam
Okay,
Chair.
thank you. I didn't mean to leave you out and just wanted to check. Brief reply, Mr. Ellerby?
And I get the hint. As Mr. Wright and Mr. Willoughby have both referenced, I was involved in the negotiations that led to the BAA. A couple of things I'd like to, in following up on Mr. Kasten's questions of Charter's lawyers, even though prior to the BAA, electric co-ops were not required to enter into pole attachment agreements, every electric cooperative in South Carolina had pole attachment agreements in place that allowed communication service providers to attach to their poles in 2020, before the Broadband Accessibility Act was passed. Many of them had clearance requirements that are the same as the National Electric Safety Code requirements that Charter has said will facilitate rural broadband. Notwithstanding that fact, there were lots of places in South Carolina, rural parts of South Carolina, where there was no broadband service, where the existing broadband providers had not seen fit to provide service. I am not offering that as a criticism. They had a business plan. Their business plan did not make sense under that business plan to go into rural areas. Perfectly legitimate. But that's the situation. That's the status quo before the BAA got adopted. The BAA, the number one driver of the BAA was making sure rural electric cooperatives could get into broadband. And that was the function, that was the driving force that led to the BAA getting adopted. Absolutely, existing providers did negotiate for requirements and restrictions and some of these provisions we've been dealing with, but the act would not have passed but for the electric cooperatives wanting to clear up, as Mr. Willoughby referenced, some of the legal issues about use of electric easements and things like that. And the idea was rural co-ops who are in the rural areas, who are owned by people who live in rural areas, they're the members, and they should be allowed and encouraged to pursue broadband in there. And that's what gave rise to this legislation. If I could find the order, Mr. Willoughby cited page 27 of the majority opinion. We are persuaded that an electric cooperative has no right to deny an attachment that complies with NESC's 40-inch clearance zone. No right. On page 23, the order says expert testimony in this proceeding further supports that the NESC is not intended to be used to establish maximum clearance requirements. For the reasons outlined above, the Commission finds the BAA does not treat NESC standards as maximum standards. We submit to y'all that that is a contradiction and it needs to be clarified, and we ask you to clarify it. I'm not going to repeat my argument from before, but the other thing I want to point, Mr. Warner a couple of times suggested that all other terms had been agreed to under the in the negotiations. What was tendered by York, including the clearance requirements, was a sort of take it or leave it. This is all a package. So if the clearance requirements change, then there may be other elements of the contract that would have to be negotiated. We would not automatically have a contract tomorrow if the commission rules under this order. If all you did was say we reaffirm, our holdings would not automatically lead to a contract that was exactly like what had been discussed, except for this change that Charter has sought from the commission. So just wanted to flag that for y'all. We do need to sit back down. We need to get this resolved, and we think we can do it, and we understand that the commission will be here to look over our shoulder if we don't cooperate in good faith to get an agreement with Charter. And I have no further argument, but I'm glad to try to answer any questions.
Any further questions for Mr. Ellaby? Hearing none, thank you, Mr. Ellaby. Mr. Wright, briefly.
Thank you, Madam Chair. Just a couple of points of clarification. Mr. Werner stated that there was no objection to finding 8, and that was a substantial portion of my argument, that we object to finding 8 and don't believe that the reference to B2 as the standard to use in measuring is appropriate, and that is what is used in finding 8 as well as conclusion 4. So I just wanted to clarify. I won't go back through that argument, but I want to clarify for the record that we do and did object to finding 8 in our argument. Madam Chair, briefly, I want to address something that you raised earlier about the denial of access. We still view that as it's difficult to view it as a denial of access where two parties are negotiating in good faith, haven't been able to come to an agreement. Their negotiating is contemplated by the BAA and under the timelines of the BAA, but can't reach an agreement. And particularly where there's an expedited statutory process to resolve those issues, it's hard to view that as a denial of access where both parties are clearly operating in good faith. The last thing I want to say is really that we're here because Charter brought this petition. They brought this petition after the passage of the BAA because they viewed the NESC standard as being established by the BAA as the standard at which attachments occurred. And it's my understanding, and based on the evidence that y'all heard and that we heard, that that's how they viewed that standard, and that was the proposal that they made. It's the NESC standard is I can't get there under the language of the BAA, that it establishes it as the standard. It's a safety standard, and that should be the #1 consideration here, because I know y'all have seen it. I've seen where electric lines have fallen on farm equipment going across a field, and it burns up a combine. I'm aware of those. But the NESC standard was brought forward by the electric cooperatives because they wanted to make sure that they weren't going to be subjected to requiring attachments at less than at something that was unsafe. It even goes back, when you look at the reference that Mr. Willoughby made to 3030 D2. If you look at that provision and its relation to the NESC, this provision is related to safety. It requires that providers ensure their compliance with the NESC for safety reasons. There's no obligation placed on the electric cooperative there in regards to the NESC standard. So when I look at the language that's in question here related to the references to the NESC, I can't reconcile for me that the NESC standard was established as the standard that would, given the petitioner's reason to believe that they could force that compliance at the NESC minimum standard for attachments. That's all I have, Madam Chair.
Thank you, Mr. Wright. Any questions for Mr. Wright? Hearing none. Thank you very much. Ladies and gentlemen, we'd like to thank y'all for appearing today and providing some additional information on your petitions and replies or responses, and just appreciate y'all's appearance today and your work on this matter. And we will notify y'all of a decision soon. We're under a timeline. And with that, if there's nothing further to come before the commission, we will close this oral argument. Thank you very much.
Ladies and gentlemen, you all did a great job. Traditionally, I would come down and greet everyone like we normally do, but I'm